Hi.
Hi.
Well, it's so nice to finally meet you.
Nice to meet you.
My name is Josh Jones, and I'll be the runner of the interview. We just need one more thing, if that's possible. Could we possibly have the passwords to your social media?
No, I don't really feel comfortable giving that to you.
Ooh, we're gonna need the passwords. That's kind of how we make our decisions on who we hire.
You don't really need my passwords. I think you just want them.
I think we do need them. That's okay.
No, I don't want to give those to you.
Miss Crandall, see, you don't...
Who here considers their search history a little shady, perhaps risque?
Definitely me.
Did you know that data brokers and social media intelligence companies can collect profiles on the websites you visit and what you search?
No.
And this means that employers can potentially buy these profiles to determine whether you're a worthy employee or not. But this is all according to Hate Crimes in Cyberspace by Danielle K. Citrone.
Wow, that's crazy and a little terrifying. However, isn't it true that employers have to comply with the FCRA, the Fair Credit Reporting Act?
Yeah.
Okay, so that means they have to inform the employee of these adverse actions, and the employee can then verify the information with a third-party agency, and they can fix whatever needs to be fixed on their social media.
Correct.
Okay.
So, let's see what some of the students here at SAM have to say about that.
Sounds great, Austin.
I think it's a good idea because people, based on social media, tells you a lot about yourself, and I feel like people should actually check social media, but it might backfire on some people. But I feel like that should be a requirement just to see the type of person you are, and just basically pretty much it.
There's a bit of a gray area because I mean, if you're going into a job that is, say, a social media intern, I think an employer should be able to see your social media, see if you're able to run it. But I don't think it's that necessary for an employer to look through your social medias. Again, because each social media represents, I mean, in my case, it represents like a different aspect of my life. So
I feel like it depends on the field of the job. If it's dealing with kids and I'm on social media posting like me pushing a kid down a slide, like, why would you want to hire me, you know? So I feel like it depends on the job.
Wow, I wonder if their opinion would change if they knew these upcoming facts.
Well, we'll see how America handles this. Did you know that currently out of 27 of 50 U.S. states, they have laws pertaining to social media research?
Wow, what states will we be talking about?
Today, we're going to be talking about Illinois and California compared to Texas.
All right. Well, according to Illinois, it shall be unlawful for any employer or prospective employer to request an individual's username and password to gain access to their social media or demand access to an individual's social media. Also, they can't request, require, or coerce an individual to authenticate or access their social media in the presence of the employer. And they can't require or coerce an individual to invite the employer to join a group associated with an individual's personal social media.
Now, for California, they aim to protect Californians from unwarranted invasions of their social media accounts. As used in Section 980, social media means an electronic service or account or electronic content, including but not limited to videos, still photographs, blogs, video blogs, podcasts, instant and text messages, emails, online services or accounts, or the internet websites.
California law also states an employer cannot request an employee's username or password or request access to an employee's personal social media account in the presence of the employer. However, if an employer believes an employee has exercised misconduct or has violated laws and regulations, an employer has the right to investigate an employee's social media. An employer may also require or request an employee's social media information if the electronic device is employer issued. Lastly, an employer cannot discipline, threaten, or retaliate against an employee or applicant for denying a request by the employer. However, this does not prohibit an employer from doing so.
Now, after hearing all that, you might be wondering, what does Texas have to say about that? And you know, Texas says nothing.
Wait, nothing? There's no law?
Not a single thing.
Wow, sounds like I need to move.
You and me both. But let's see what some professionals here at SAM have to say about that.
All right. My name is Dr. Natalie Baker. I'm Associate Professor of Security Studies in the College of Criminal Justice. I mean, that's basically it, you know, in terms of personal presence on social media. If you're doing some shenanigans like posting funny or scandalous memes, like that's different, right? Like your personality isn't going to factor in as much as if you're saying really offensive stuff that borders on things that we're not going to hire. That is in contrast with our philosophy in terms of our department and in terms of the school's philosophy, right? And of we're in criminal justice, so clearly we have a certain mission, and if that goes against our mission, we're not going to, hire someone who's directly in opposition to that.
I am Zachary Bachman, and I'm a lecturer in philosophy at Sam Houston State University. I mean, there's some jobs where you're on the job all the time, but those jobs are few and far between, and they should pay a lot of money when that's the case. Well, let me put it this way. When the arms of our employer reach into our private life, there's less the sense in which we are an individual pursuing our conception of the good life. And we become more and more a cog in a machine where the machine is our employer. And we lose individuality, and we, in many ways, I would say, lose much of what's important in life. Life is more than what we do for a living. And when we are solely guided by our job, then the kind of value that we can pursue in life is narrowed greatly. And so it's incredibly important, I think, for employers to respect the fact that employees have a life of their own.
I'm Juliana Lilly, and I teach at Sam Houston State University. My area is organizational behavior and human resource management, and I've been here since 2002. Many employers today are asking applicants to provide, access to their social media accounts, and they do look at that before, either before the interview or after they've interviewed people. They said, for the next step, you need to give us access so we can just sort of see what you are posting online. They have some valid reasons for doing that, because if you're posting things that are going to embarrass the company, they are going to not want you to do that. And also, if you're doing things that are illegal, some people post things that are clearly illegal and they show the whole world that they're doing something illegal. They want to know that too, because number one, they don't want someone who is violating the law probably working for them. And number two, if you don't have enough sense to know you shouldn't do that, that also suggests your ability to make good decisions in the workplace. I think the best advice would be just make sure that whatever you post online is appropriate.
Well, that was really informative, but do we have a case to look over?
We actually do. It's called Mahoit versus Home Depot. So, in Mahoit versus Home Depot, defendant Home Depot requested an order compelling plaintiff Danielle Mahoit to produce documents that test her claim of distressed emotional and mental state. Mahoit is suing Home Depot. Now, according to Rule 34A, a party may request documents in the responding party's possession, custody, or control. And 34B requires that requesting a party to describe the items to be produced with reasonable particularity and specify a reasonable time, place, and manner for the inspection. The court recognizes that social networking site content may be subject to discovery under Rule 34.
The court finds that 3 of 4 categories of social networking service communications sought by the defendant failed. Category 1 seeks any profiles, postings, or messages from any social networking site from October 2005 to 2012. The broad description of the material requested fails to put a reasonable person of ordinary intelligence on notice of which specific documents of information would be responsive to the request. Category 2 requests third-party communications to plaintiff that place her own communications in context. This also fails because plaintiff's own communications regarding emotions are entirely predicted in Category 1. Category 4 requests any pictures of plaintiff taken during the relevant time period and posted on plaintiff's profile or linked to her profile. This is impermissibly overboard. The defendant fails to make a threshold showing that every picture of plaintiff taken over a 7-year period posted on her profile by her would be considered relevant. However, Category 3 requests communications between plaintiff and co-workers. This is feasible, calculated, and not overburdensome. Therefore, the court grants this request, and plaintiff is ordered to provide documentation within 14 days of this order.
Wow, it sounds like she won.
Overall, she did, in compliance with Categories 1, 2, and 4, and partly in Category 3, with the plaintiff's request to document her mental state.
So, that's all really informative and everything, but what should we do to protect ourselves?
Well, all we can really do is just be careful what we like, share, and post. I mean, you just have to be careful on social media.
And you have to know your rights and your laws in the country that you live in.
Well, this has been Austin Patrick
and Mikayla Dallas.
Thank you for watching.
Bye.